Hi, I'm Adam Katz for DogTrainerToolbox.com, as well as the Dog Trainer Marketing Group on Facebook. And I'm here today with Angela Langlotz, the trademark doctor, who is going to spend a little bit of time with us telling us everything she knows within a 20-minute period or so about what you, as a professional dog training business owner, needs to know about things like trademark and copyright and all that kind of cool stuff. How are you doing today? You look magnificent.
Thank you. Thank you so much. I try to look magnificent. I've got some weird lighting going on here, but that's okay.
I feel you. I feel you. So listen, I'm going to jump into these questions and we'll see where it takes us. I'm a little bit technologically challenged with Zoom today,
That's
so I'm going to be
okay.
clicking back and forth, but hopefully all of this works and I believe it is recording. So the first question I had was, what is really the difference between copyright, copywriting
Yeah.
with a WRITE,
Yep.
the little registered mark that you see everywhere,
hmm
trademark, and patent.
Wow, that is a big question. And I'll get the easy stuff out of the way first. So, copywriting with the WRITE, that is the process of writing sales copy.
Copy.
Okay, so that's what that is. And we're going to set that aside because
Hmm.
that's not what we're talking about today. Today, we're talking about intellectual property. And you can think of intellectual property as an umbrella. And under that umbrella, there are different types of intellectual property. Things like trade secret, things like copyright. So copy, RIGHT. In other words,
Right.
the right of an author to their creative works. That's copyright. Trademarks, which are protection for brands, and then patents, which are in general, they're design patents, but we're not going to talk about those here. In general, patents are protection for useful inventions, and a useful invention can be a gadget of some sort, or it can be something, excuse me, less tangible, like a business method. What's an example of a business method? It can be something like Amazon's one-click ordering. That used to be revolutionary. Of course, it's not now, but in the early noughties, that was revolutionary, and they did have a patent on that for a business method, since expired. Okay, so the three main types of intellectual property, remember our umbrella, that we talk about here are going to be trademarks, which are protection for brands, copyright, which is protection for your creative works, things like process manuals. An iPhone has just joined the chat, Adam.
Oh,
Do you see it?
um, let me put on my old man glasses again.
Okay.
Yes, I see it. I have no idea who that is, but I guess somebody's watching.
Oh, somebody's watching. Well, welcome, somebody. I'm glad you're here. Okay. I didn't know what was going on here. I forgot that we were inviting people. So, hello, whoever joined iPhone. So, we were talking about copyright, RIGHT, and protection for creative works, things like process manuals. Maybe it's a course, maybe it's videos, maybe it's a website, website articles, things like that. Basically, anything creative that you create is capable of copyright protection. And then there are patents. So patents are protection for useful inventions. And I don't really deal with that in my practice because I practice trademark and copyright law, but not patent law.
Okay.
So those are the difference between the three. Most of my clients either need help with copyright protection or creative works, or they need help with trademark protection for their brands. So when we talk about and also this question asked about what's the difference between registered and TM. So the difference is when we claim rights to a trademark, even if it's not registered, we can use the TM symbol to put
Sorry,
other
sorry.
people on
I need you to
notice.
say that again. When we claim rights to a trademark, sorry.
Yeah, so let's say, for example, that you have something that you're claiming as a trademark, but you haven't bothered to register it yet. You can actually put the TM by that,
Okay.
to show other people that you're using that as a trademark. You're claiming a right to trademark on that, even though you don't yet have a trademark registration. When you get a trademark registration through the United States Patent and Trademark Office, this is what a registration looks like. This one's since expired, but this is a trademark certificate. Okay,
Fancy.
so you can get one of these. So when you get one of those, you can use the circle R to show everybody else, hey, I have a registered trademark, right? So
So
that's
that
the
I'm guessing
difference.
that provides some additional level of protection beyond just me putting TM next to.
Yes, there are lots of advantages to a registered trademark. Among those are you have a listing in the registration database at the trademark office. So if somebody else tries to apply for something confusingly similar to your trademark, the United States Trademark Office will say, sorry, we already have one of those. Try again, right? So in essence, the trademark examiners sort of serve as a trademark watchdog to prevent other people from registering confusingly similar things. And then you also get one of these, which is a way to prove your ownership of the trademark. If you have an unregistered trademark, then you can't really prove that you own it, right? You don't get a trademark certificate to prove that you own it. So all you can say is kind of a wimpy, well, I own that because I was using it first, but there's a whole bunch of stuff you're going to have to prove in order to assert your trademark rights. And anytime your attorney says there's a whole bunch of stuff you're going to have to prove, just start adding up the dollar signs for that. Okay. So it's really a
Gotcha.
lot
Okay.
cheaper to just get a registered trademark, one of these. And then you have proof of what the trademark is, the date that you first used it, the goods and services that are covered by it, the owner of the trademark. So there's a lot of stuff that's evidenced on this certificate. These are now electronic, by the way. If you want one of these, you can buy one, but
I
you get an
I want one.
electronic certificate. Yeah, suitable for framing. You
Yeah.
get an electronic certificate that says basically, here's who the owner of the trademark is, here's what their trademark is, here's the goods and services it covers, and here's their date of first use. Now you don't have to go prove all of those things. And so when you tell somebody, hey, please stop using my trademark, here's my trademark certificate that proves I own it and what I own, then it's a lot easier to get your infringers to stop. If you don't have a trademark certificate, it's nearly impossible to get your infringers to stop.
So I can't
Quite
just go over to
easily.
like the Wayback Machine and say, "Hey, look, I was using this back in 2006 and you
That
weren't."
helps. That
Okay.
helps. But until you have one of these, again, you're
Gotcha.
stuck proving.
Gotcha. Okay.
Okay.
So a
Um,
trademark might be, for example, if I set up my business and call it Cats Trains Dogs,
mhm.
and that becomes my trademark, and I don't want any other Catses using that name,
Yeah.
that becomes my trademark. And then once I register it, I change. I technically do I have to change all my signage and business
To
cards
what?
from TM to R?
You don't have to, but if you
Okay.
have a circle R, then
It's kind of like a warning message to everybody else
yeah,
that
I
like
mean
I
the
got my shit
TM is
together.
kind of a warning message too, but you don't have to change it to circle R,
Right.
but when you have new business cards printed, you could add the
Yeah.
circle R in
Okay.
just as things get updated. But I love
Okay.
that. Cats trains dogs.
That was the name of my, I've had three dog training businesses over the past 30 years. That was
Uh-huh.
the name of the third one. And
I love it.
I was real worried in the beginning because the first day that, we launched the business, I pull up at a stoplight and somebody sees the graphics on the side of my truck and he rolls
Yeah.
down his window and he says, "Hey, are you into trains?" And I'm
A
like,
what?
"What?" He says, "Well, I'm into
Oh,
dogs and I'm into trains. Like, can we be friends?" I'm like, "No, I train dogs, you idiot."
yeah.
So I
Trains
was,
as a verb and not as a noun.
yeah.
Yeah.
So it all worked out.
Okay.
So here's what I'm thinking. So let's say a lot of us in the professional dog training industry, we use what's called a remote collar. What it is,
Hmm.
it's a transmitter that if you use it correctly, it just sends like a tapping sensation on the dog's neck.
Yeah.
It's not like back in the 70s when they'd shock the dogs and the dogs would jump. So it's
Yeah.
it's very humane, but it's a way of communicating with the dog at a distance.
Hmm.
And there are different ways of using the collar. Like some people use it as more of a tapping sensation, like tap, tap,
Mhm.
tap. Other people use it as a constant stim, and then when the dog does the behavior, he shuts it off, or different methodologies. So would I be able to? What would that be? Would it be a patent? Would it be a,
So, in order to be
a
eligible
copyright?
for patent protection, it has to be new and non-obvious,
Okay,
right?
okay,
So,
that's a
if
good.
it's new and
Yeah.
non-obvious, then it's capable of patent protection. But if it's obvious, it's not capable of patent protection. So, if it's obvious to
Mm,
use whatever in that way, and I think the
right.
answer probably is that's obvious, right? Because it's set up to do that. Probably not capable of patent protection.
Gotcha. Interesting. Interesting. Okay. And I know that's not really your area of focus per
It's
se,
not.
but
Yeah.
um, but I thought it might be coming into this interview, so it's good that you clarified.
Yeah.
Let me hang on a sec. Let me just watch the time and pull up my notes. Um, do I really need a registered trademark for my business name or logo, or are common law rights sufficient for a dog training business? I guess in other words, how likely is it that I would actually need to go through this whole process?
Yeah. So let me explain what common law trademark rights are for a minute. You get trademark rights at common law, even if you don't register, just by using the trademark. However, you only get the rights where you're actually using the trademark. And
Say that again. You
you
only get, I don't
only
understand what that means.
you get common law rights in the geographic area where you're actually using the trademark. So
Okay.
let's say that you have a business in Texas, in Dallas, and you're using the trademark in Dallas. You would have trademark rights in Dallas, but if you wanted to expand to Houston and there's somebody else using something similar already in Houston,
Mm,
you can't expand, right?
right.
You might get nationwide common law trademark rights by putting up a website. But again, do we want to fight about that?
Right.
Right? Because remember, at common law, you get trademark rights, but you don't get one of these.
Uh-huh.
So you have maybe have rights, but you can't prove them. So if you want to expand, you might say, well, I have common law rights dating back to this date, January 1st, 2020, because I put up a website on January 1st, 2020, and you want to expand to Oklahoma, and there's somebody who started using a trademark confusingly similar to yours in Oklahoma, and you want them to stop, and they basically tell you, forget it, we're not stopping. How do you assert your trademark rights?
Right.
You can
So if
sue
I
them in
register,
Oklahoma, but you can't sue them in federal court because you don't have a federal trademark. So you're going to have to go around and sue in every state court in order to enforce your trademark rights. You can't sue in federal court. And you're going to have to prove all of the things that are on this trademark certificate that you wouldn't have had to do if you had just registered your trademark. It is always less expensive to register a trademark at the United States Patent and Trademark Office than it is to litigate over your trademark rights. And having a trademark registration that you can wave around and say, listen, you're using my trademark, that's going to be much more likely to get that person to stop than if you don't have a trademark registration. They're going to say, so what? I don't see that you have any rights. All you're doing is you're coming to me and you're saying you have rights, but I don't see that you have any rights. You don't have a trademark registered. So how do I know you're not just bluffing in order to bully me to give up the trademark?
interesting.
Yeah.
So so um so because it's under federal jurisdiction, once you register the trademark,
Mhm.
does that mean I don't have to go to court? Or I
You're
would still
less likely to have to
be
go to
less likely.
court
Okay.
because you have a trademark certificate that sets forth what your rights are, and your infringer can see this.
Okay.
Without this, the infringer is going to say, so what? Prove it. Sue me.
Perfect. Perfect.
And not
Well,
just only sue me, but sue every infringer in every state of the union instead of just bringing everybody into federal court wherever there's jurisdiction and saying, y'all got to stop.
Oh, I see. So there's an advantage if there's 10 different people in 10 different jurisdictions, but they all fall under federal, I can bring them all under one lawsuit. Is that I don't have to
I'm not a litigator.
we're we're getting into the weeds. Gotcha.
Right. We're getting into the weeds here.
Okay.
You have to sue where jurisdiction is proper, and that might be different places for different people, depending on how they're using the trademark, et cetera, depending on where they are. But the point is that if you don't have a federal trademark, you can't enforce your trademark by suing in federal court. You're going to have to go to every state where that person is infringing your trademark and sue them. It's going to cost you a lot of money to enforce your trademark is the
Okay.
point. Whereas if you just pay and get a trademark registration, my God, it's less than $3,000. Why wouldn't you? You
But you'd
know,
have to go and even though it falls under federal jurisdiction, you'd have to go and sue
you have
each
to
individual
sue.
person anyways, wouldn't you?
That's true. But if my infringer is using it in Oklahoma and New Mexico, I can't go into federal court without a federal trademark registration. The federal court does not have any jurisdiction. I have to go into Oklahoma and sue them in Oklahoma under state trademark laws. And then I've got to go sue them in New Mexico under New Mexico trademark laws.
Gotcha.
So it just causes more. I know everyone's like, I don't want to get a trademark. It's like, fine, you don't have to. It's a free country, but you're going to make your life more complicated and more expensive if you ever need to enforce your trademark rights. So,
Gotcha. Okay, so now I'm totally sold. I want a trademark. What typically am I looking at as far as cost? You mentioned 3,000. Is that for the registration plus the legal, or is that kind of ballpark?
yeah, it's about $3,000 to register a trademark for one class. Okay. And don't see this video 5 years from now and go, Angela, you said it was
Yeah,
$3,000 and now it's four. This is
yeah,
2025. Okay. That's
yeah,
about what it
yeah.
what it costs for one class of goods. If you want to expand your trademark into other classes of goods, it may be more expensive. But I guarantee you that getting a trademark registration and being able to effectively enforce your trademark is going to be less expensive than not getting the registration and then trying to enforce your trademark.
Gotcha,
So
gotcha. Okay, I know you're pressed for time, so lightning round. Uh, top three things.
I have 40 more minutes. I budgeted until 10 a.m. for you, Adam.
Oh, we started at 10 a.m. You mean 11?
I'm sorry. Yeah, 11
Oh,
a.m.
okay. All right, cool. Let's do lightning round anyways.
Okay.
Top three things that come into your head about what um, most of the clients that you work with
Mm-hmm.
have wrong when they first walk through the door.
Mm.
Like if you had a magic wand and you could say, you know what, I wish they just, I don't have to say this ever again because they just knew this. What would those two or three things maybe be? I'm putting you on the
Um,
spot.
I mean, everybody's different, but one of the things I wish that people understood, and it's okay, I assume that my clients don't know anything when they come to
Yeah,
me. And so I
that's why we're
explain
hiring you.
everything. I
Yeah,
explain everything to them. But when we apply to register a trademark, we have to use it exactly how we've applied it. So sometimes I have clients come to me, they're saying, this is my trademark. My trademark is cats trains dogs. Okay. So we apply for the trademark cats trains dogs. And then my client says, okay, here's my proof that I'm using cats trains dogs. And it says the trademark that they're actually using is cats, the cats trains dogs, or Adam Cats trains dogs. And I'm like, well, I can't use that as proof for cats trains dogs because it's different than what we filed, right? So if we're going to file a trademark application for this certain mark, cats, trains, dogs, then I need to show use to the trademark examiner that is exactly that, cats, trains, dogs. Or sometimes the client will show me use and then they'll take it down. So the trademark examiner can't see it when they go to examine the trademark application 4 to 6 months after it's filed. The client's taken it down.
okay.
So I tell them, don't do anything to this page that we have used as proof of your use, right?
Right, right,
Leave it alone. Please don't touch it. You can make a
right.
copy of it, whatever, but please don't change the use here, right? Like, we filed an application for this logo and then the client changes their logo. I'm like, what are
Right.
you doing?
Yeah, that's not what
Why
you
did,
registered. Right.
right? Why did you not ask me before you did that? Well, we changed the logo. I'm like, okay, we're done. We can't, we need to reapply. If you change the logo, we need to reapply, right?
Right.
Which is why I prefer to register word marks instead of logo marks, because if we apply to register a logo mark, then we have to use it as that logo, right? So I wish that
So the
clients,
word mark is much broader, is what you're saying.
yes, I prefer to register word marks, or I prefer to apply to register word marks. Sometimes we can't do that because of other things that are in the database. I won't go
Mhm.
into that because it's a lot to explain. But I do prefer to register word marks over logo marks because it's easier to you can use the word mark in any font or script or logo or form. It's always the word mark, but the
Right.
logo, if you change the logo like even a little bit,
Hmm.
it's crazy how picky the trademark office is. They won't let you make any variation to that logo, no matter how small. So if you want
Okay.
to change the logo, you're going to have to reapply.
Gotcha. Great.
And I know
That's
you asked
gold.
me for three things, but I can only think of two.
That's all right. I got one. So
Okay.
let me go back to kind of what you said before because I'm not sure I'm clear on it. I have a
Okay.
friend. He has trademarked the term invisible leash or registered. I'm not sure how you
Uh-huh.
refer to it.
Yeah, I've
Invisible
heard of
leash.
invisible leash. Yeah.
Right. And so if if I was operating under the name the invisible leash, were you
Hmm.
saying that I could get away with that or I couldn't
No,
get away with that? I
no, no,
could.
no. So there are two different issues here. One is an infringement issue. Okay. So if you're using the invisible leash, you're still infringing the invisible leash trademark application.
Okay.
Why? Because you cannot incorporate the entirety of someone else's trademark into your own. So if someone
Wait, wait.
owns
You
the
you can't you
trademark,
can't incorporate the entirety of
mhm,
somebody else's trademark into your own. Okay.
yes. So if somebody owns the trademark invisible leash, you can't add the onto the front and say, oh, I'm not infringing your trademark. I added a
Mm,
the, right?
right.
And
Okay.
you can't add like ES on the end. So you can't say invisible leashes and then go, oh, I'm not infringing your trademark.
Oh,
I
you
added an
can't.
S on the end, right?
That's
No,
interesting.
it doesn't work that way. Although
Or an
I have
ES,
people try
right?
to do that all the time, right? And I'm like, no, it
Yeah.
doesn't work that
Oh,
way.
that's good. At least there's a little bit of common sense. Right.
Yeah.
So how did they
Yeah.
get around, for example, fried chicken? Is that, Joe's Fried Chicken versus Jim Bob's Fried Chicken? Is it because fried chicken is just
So
considered
fried
generic?
chicken, assuming we're selling fried
Mhm.
chicken is descriptive for the goods.
Is
So
this
we don't give you a descriptive trademark. You will not be allowed to exclude other people from using descriptive terms that are in your trademark. Why? Because other people have the right to say that they sell fried chicken as well.
so? To bring it back to dog training, if
Mhm.
my name's Matt and I open up
Mhm.
Matt's dog training, am I able to prevent somebody else from calling their dog training business Matt's dog training?
You may be able to prevent them from using the term mats for dog training, but dog training will have to be disclaimed apart from your trademark. Okay, so we say it, we are disclaiming the exclusive right to use dog training apart from the mark as shown. So you have the exclusive right to use Matt's dog training, but the terms dog training, because they're descriptive, you
Right,
cannot prevent other people from fairly describing their goods and services. Why? Because that's not what trademarks are for. Remember, the purpose of trademarks is to avoid consumer confusion. So we're essentially giving you a monopoly on certain words or symbols or phrases. That's what you get when you get a trademark. Nobody else can use the swoosh. Nobody else can use the Adidas three stripes on certain goods and services, right? They have essentially been granted a monopoly on those distinctive trademarks. Okay, so those distinctive words or symbols or phrases, but not anything that's descriptive. So if I'm Adidas and I want to register the words Adidas sportswear, I get coverage for Adidas, but not sportswear. I don't get the exclusive right to the
right.
word sportswear because other people who make sportswear also have the right to say that they make sportswear.
Now, in
So,
the real world, though, if my name's Jim McDonald's and I
mm-hmm,
open up McDonald's dog training,
mm-hmm.
what happens?
What do you mean?
Or let's say my name is Randolph Disney and I open up Disney dog training. What happens in the real world, right?
In the real world, since Disney is a famous mark, so famous marks get extra protection against something called dilution. And dilution is basically, how do I explain? If you have a famous trademark, nobody else can use that mark for anything. Why? Because it is very common to have sort of co-branding agreements. So let's say that you're Tiffany's jewelry store. You sell jewelry, you sell housewares, you sell all sorts of other things, and you want to open a restaurant. You can do that. Tiffany's is a famous mark. You basically have coverage as a famous mark for anything under the name
Wow.
Tiffany's. Okay. And
Wow.
they have since opened a
It's so
restaurant.
fascinating.
So you can now eat breakfast at Tiffany's because they have a restaurant, right? It's all done in this Tiffany blue.
Tiffany's, the company, has a restaurant,
They
some
do.
agreement. Wow.
They moved into restaurant services.
Fascinating. And so the Warner Brothers or whoever owns the rights to the movie name Tiffany's, there's no.
It's breakfast at Tiffany's, and you can't register a trademark for the title of a singular work. So if the title of your movie is Breakfast at Tiffany's, that's a title, it's not trademark use.
Is not
So
even though it may be
it's a mo
copyright. What?
well, they have copyright rights for the movie itself, but you can't register a copyright for a short phrase. So the phrase breakfast at Tiffany's is not capable of protection under copyright law because it's not capable. It's a short phrase, so it's not capable of being registerable because it's not sufficiently creative to reach that creativity threshold that's required for copyright registration. But the whole movie is capable of being registered as a copyright, and I assume that it has been.
Let me just jump in, folks. For
Sure.
those of you watching at home or watching at a later time, this is why you need to hire someone like Angela, because not only is she more than likely a lot smarter than us common folk,
I
but
don't know about
she's
that.
a pro. And look, I took business law classes at the Haas School of Business in Northern California years ago, and even this is kind of gets so into the detail of it that it really makes sense. I think if you have a dog training business, if you're looking, especially if you're looking to expand into multiple markets,
Mhm.
you need to get with someone like Angela or someone like Angela to help you navigate this, because this is the complexities of this. I could see getting very, very complicated very, very quickly. Am I right?
Yeah. And part of the problem too is that people don't know what they can protect and what they can't protect.
Right.
Right. So I sometimes come up with ideas. I'm like, well, you're using this logo. Is this logo important to you? Would you be upset if somebody else copied this logo for their dog training business? If the answer is yes, then consider protecting that with a trademark registration. If you would be upset if somebody else, you're trying to franchise the business and some competitor stole your process manual, your business process manual, that's capable of protection under copyright.
Mm.
So, there are things that business owners can protect that they don't even realize. So when I meet with a client, I explore, what is your business and what kinds of goals do you have? Are you going to franchise it? Are you going to keep it small? What are you doing? So then I know what's appropriate to suggest to the client, because what's appropriate for somebody who might want to franchise or license their business isn't appropriate to somebody who just wants to run, a kennel and not franchise it. So it really depends on what the client needs. There's no one size fits all prescription.
Now, I write on the subject of copyright. I,
Mhm.
I open up a dog training business. I write a killer website with killer Gary Halbert, Dan Kennedy style
Yeah.
copy, and it's brilliant, and it starts converting twice as good as anything else I've ever seen. Every
Mhm.
time I send traffic to it, and it's wonderful. And then a couple months down the line, I noticed that Joe down the street, he has basically, he's taken to paraphrase the Beatles, he's taken my song yesterday and he's changed it to the other day, and he's now outperforming that song. He's taken my copy, Get Your Dog to Listen to You Anywhere You Go, and
Hmm.
he's changed it to Get My Dogs. So how my understanding is that once you create something in America, at least, it is
Yeah.
immediately protected under copyright. Is that true or not true?
That's true, but unless you have a copyright registration with the United States Copyright Office, it's really hard to enforce that copyright. So you can't get into federal court to sue for copyright infringement unless you have a copyright registration. So,
Gotcha. Gotcha. So it'd have to be by state or by county, or
yeah, you could
just
probably
get
sue in
messy.
state court. But again, proof,
Right.
you don't have a registration. How are you going to prove what you created, when you created it, you know, all of that? It's another one of those proof issues. Um,
But with the internet, though, I mean, everything is recorded. So
sure,
I have a hard time.
that helps.
Does that not hold up, or
It helps, right?
okay?
May help, but then you're counting on the Wayback Machine run by somebody else to have scraped your website. The Wayback Machine, we know it does not scrape your website as soon as you put it up. So if you're relying on that for proof, it might take weeks or months for the Wayback Machine to scrape your website. What are you
Okay.
doing in the meantime?
Well, I think, for example, like if I created a video, and uploaded that to YouTube, it's time stamped.
Sure.
I
Yeah.
mean,
And
but the copyright's a lot
look,
cheaper than trademark, isn't it?
um, the filing fees are a lot less, right? I mean,
Okay.
depending on the work that's being registered, the filing fees can be, 45 to $80.
Okay.
And yes, it's less expensive to apply to register copyright because it's less complicated. We don't do a clearance search before we apply to register a copyright. So, people can do that. I'm going to be putting out a course about how to register your own copyright because it's pretty expensive for me to do it. But I think people, could really do it themselves if they have the right guidance. The
Let, let,
copyright
let, let me know when that
application.
goes live, and I'll
Okay.
put it up on dogtrainertoolbox.com so that other, dog trainers can find it and
Okay.
use it to
Yeah,
their
I'll
benefit.
do that.
So cool.
Um, but it's once again we have these issues of proof. Like, how are you going to prove when you put it up? If it's a video, sure, that's easier, assuming it doesn't get taken down, right? If you're putting it up on
Okay.
somebody else's platform, you're at their mercy.
Right.
And your competition can have your stuff pulled down pretty easily because all they have to do is make some kind of lame
Right.
copyright complaint to YouTube, and YouTube will pull it down.
Right. Right.
YouTube has actually threatened me for making copyright complaints on behalf of clients. They threatened
Amazing.
to take down my um, channel, which has over 600 videos on it, because I made a legitimate copyright complaint from somebody who like literally ripped off all of my client stuff. It was
That's
insane.
that's crazy. Yeah.
I was like, what are you talking about? I'm the guy's attorney.
Yeah.
Of course I'm making a copyright
Did
complaint on behalf of my client. And it's the exact same video on the infringer's YouTube channel. And you can see that my guy put it up first and it's got his trademark on it and everything. And then YouTube sends me a nastygram saying, oh, we're considering taking down your YouTube channel with over 600 videos on it because you're making copyright complaints on behalf of your clients at YouTube.
what happened?
They didn't take my channel down, but I was like, I think I probably need to make a course to teach people how to do this because this represents my making complaints on behalf of the clients represents a threat to my own YouTube channel, which is
Amazing.
complete insanity,
It
right?
is. It is. Yeah. Wow. And what's your alternative? I mean, Rumble? Really? Like you're gonna go over to,
Yeah.
where nobody's watching?
Yeah,
It's
exactly. I mean,
it's it's
YouTube is the big daddy,
it
right?
is.
It's the
It's a
big daddy
monopoly.
where it's where people go to find video information. And I get a
Yeah.
lot of clients from my YouTube videos.
Smart.
But Rumble, it's like, yeah, people go to
Yeah.
Rumble, but it's sort of an alternative aliens ate my face.
Yeah. Yeah.
You know what I
Yeah.
mean?
Yeah.
It's where weirdos and and I mean this sort of tongue in cheek, right?
Yeah.
It's where the weird videos go that
It's where the
YouTube
weird
is
kids go.
like,
Yeah.
this is too weird for us. We're taking your video down. So then it
Mm,
goes to Rumble because Rumble will let you put up anything, right? And a lot of
yeah.
times these YouTube takedowns are completely illegitimate. They just don't like, the person's politics or whatever.
Hmm.
Like they took down a bunch of vaccine videos. Can I even say that? Should I just say they took down a bunch of information about that because they didn't like the information, not because it was objectively untrue. So, I mean, they did a lot of weird stuff during the vid, right? So they
Hmm.
took down a bunch of stuff. They engaged in some, to me, sort of questionable tax against free speech, but fine, it's their platform. They get to do whatever they want.
Right.
And that's what you're signing up for when you start uploading things to YouTube, right? If YouTube doesn't like you for some reason, and they don't have to have a reason, okay? They can just arbitrarily decide one day that they're pulling your stuff down and that's it. So, you know, you have to be careful. But yeah, you can make a complaint to YouTube. I don't even know how I got off on this rant. Um,
I don't know, but I like
sorry. All
it.
right. No, I'm a big proponent of free speech and I don't like censorship, right? Like
Mm,
I don't care whether I like the thing that the person is saying or not. I think everybody has the right to speak, but then the counter to that is, well, it's YouTube's platform. Also
right.
true, right? So YouTube has the right to regulate what's published on their platform, and I'm also in favor of that. So, I
Mm,
can see both sides of this. But anyway, yeah, you can have your stuff pulled down. So if you're looking for proof later, what if YouTube has just arbitrarily decided to nuke your channel? There goes your proof. Now, how are you going to prove who published what when you didn't file a trademark?
that was a
I'm sorry, a
beautiful
copyright.
weave, by the way. The way
What?
that was a
Yeah.
beautiful weave. The
Yeah.
way you went and you brought it back.
Yeah.
Beautiful.
I always
Beautiful.
come back. I always circle back.
Good for you. I don't. I get lost in the weeds, and pretty soon we're talking about breeding iguanas, and like, how did we get here?
Right? It's like, how did we get here? Well, I call it taking a sidebar and I always try to circle back. Right.
Nice,
So,
nice.
yeah, if you're looking for proof and somebody's taken down your stuff, how do you prove that? Well,
Right.
without a copyright, registration, it's hard to prove who did what when. So, I'm always in favor, if you want to protect your stuff, register it.
Mm, good.
Okay.
Good advice. Good advice. So listen, I want to kind of wrap this up because I want to
Okay.
be respectful of your time and
Sure.
but how can people watching get in touch with you and if you like to promote if you have info products or you're coming out with info products or anything else, I think the world of you. I think you explain things really super clear. You're obviously highly intelligent, and anything I
Thank
can do
you.
to help you out, just let me know. So
Yeah.
please, by all means.
Okay, so people can find me online at trademarkdoctor.net. I'm also on YouTube with over 600 trademark and copyright law videos. I'm at Trademark Doctor on YouTube. There is a really great playlist where it's 9 videos in less than 20 minutes. You can get a basic primer about copyright, trademark, and patent law. It's a playlist. If you look in the playlist area of my
Mhm.
YouTube channel, you can see it. It's called intellectual property basics or maybe trademark basics or something like that, but it's the basics playlist. And I like those. And also you can do a search on the channel and probably find me, my head talking about whatever it is you're looking for about trademark law. You can find me online at trademarkdoctor.net. You can book a short consultation with me if you have trademark questions that you need answered, just sort of basic things that you want to talk about. You can book a consultation. It's $25. And you can talk to me and we can get your questions answered. I am coming out with some courses. I actually do have some courses. I'm moving things over from ClickFunnels to a different platform. And so,
I got to ask, what are you using? What platform?
System. System.
Okay,
Yeah, so
system.io,
I'm in the
right?
process of uploading everything to System. ClickFunnels just got too wacky and
Hmm.
kind of weird with the format and the support and everything. So I was like, I'm not liking this so much anymore. So I'm moving everything over. So yes, I will have courses about how to register a copyright and um, how to do a a copyright takedown, right? Because I'm not doing those anymore after I got threatened. So I was like,
Right.
I got to make a
Smart.
course. I got to teach people how to do this so they can do it themselves. Because for me, it just
There's too
represents,
much liability.
well, it represents a liability in the sense that I don't want to get my channel pulled down, right? Like
Right.
if I start making copyright complaints for a bunch of people and I get my channel pulled down, oh my God, I mean, that would be catastrophic for my business.
Wow.
So, because a lot of people find me based on searches that they do that bring up videos that answer those questions. So, a lot of people come to me and they'll say, I saw your YouTube video and, right?
I feel you. 100. I mean, a lot of my market finds me through my YouTube channel. So it's a
Yeah.
great marketing platform. In fact, I tell
Yeah.
dog trainers if you're not, putting your own dog training videos up,
Yeah.
and optimizing, the titles for, city and, dog trainer in that type of thing, you're missing
Mhm.
out on a lot. So
Yeah. Yeah. It's a great platform for that. And I love YouTube. I really do. But also, it's risky
CYA,
sometimes,
yeah.
so it's kind of a double-edged sword. So you got to be careful.
Right, right.
Um, yeah. What else? Where else can people find me? I mean, I'm on the various platforms. My favorite platform is Facebook. I do publish some things on Instagram. But I like Facebook because all of my entrepreneur family, we're
Yeah,
all on
yeah.
Facebook. We're all hanging out in Facebook groups. So that's where I hang out too. Um, and yeah, I have a lot of different clients. Most of my clients are creatives. So when I say creatives, I mean they're publishing, training materials or online courses, and I do have some dog trainers that have hired me to register their trademarks for their dog training businesses. Um, yeah, so most of my clients create products and services and teaching and training and courses, and they sell them online. So I represent, in large part, I do have some brick and mortar businesses that are clients as well, but in large part, my clientele is
A lot of
creatives,
creators.
online creatives. Yeah.
Right, right. Super, super. Well, Angela, I cannot thank you enough. You've
Thank
been
you,
awesome,
Adam.
and hope to. I'm sure we'll cross paths again at some point, and
Of course.
kind of go from there.
Okay.
So,
And I have
hey,
this whole list of questions that we didn't even talk
I
about.
know
This
I
is,
feel like we should do like a seminar or something at some point, like a
oh, you know
multi-hour.
what? I'm going to make some videos.
Good. Right on. Right on. I'm Adam Katz for dogtrainertoolbox.com. If you have questions, you can join us at the Dog Trainer Marketing Group on Facebook. It is free to join. You'll be amongst over 5,300 professional dog training business owners swapping secret strategies, tactics, and tips on how to grow your dog training, how to start, grow, and profit from your dog training business while helping dog owners have a more satisfying and successful relationship with their dogs. Hey, again, I'm Adam Katz, dogtrainertoolbox.com. We'll talk to you soon, guys. Angela, please stick around.